protected health information as well as protected health information in other forms such as verbal and paper. I've conducted somewhere upwards of 1,000 risk analysis throughout my career for covered entities and business associates of all shapes and sizes, big, small, short, and tall. So I've seen just about every possible way health records can be accessed, transmitted, or stored throughout my career. I've also worked on behalf of the federal government as a contracted auditor. So anytime I approach the subject matter, I always look at it from the sense of, are we not just securing records, but are we protecting ourselves, and are we able to provide what the federal government is looking for in an eventual audit, which I'll talk about a little as we move through here. And more importantly, the most dangerous aspect we face under this law is not the federal government, it's trial attorneys. People can now sue. Ever since the HIPAA omnibus rule, ever since 2013, late of 2013, folks can now sue under their state laws of negligence for wrongful disclosures of their protected health information. And I'll talk a little bit about that as well. So let's jump into this. We have quite a few slides here, so I'll try to wrap up at the end here and give you guys some little bit of time for Q&A should you have any for me. So if you think of HIPAA, just a real quick background, we're going to fly through this, but in the old days, it left us alone. We're like this kangaroo hopping around. Yes, laws were on the books, but they really weren't being enforced. So unfortunately, that is not the case anymore. Ever since true enforcement really began in September of 2013, that's really when the government got extra serious about this. So no longer can we ignore the law. The trial attorneys in federal government are the shark. We now are the kangaroo. Signed into law way back in 1996. It's interesting, when you think of the word HIPAA, most of us think about securing health records, right? That's really not what the whole concept of this law was about from the beginning. It's a very robust law. It's about portability of your health insurance. That was what the basis of the whole law was to begin with. It's always been bipartisan. So I get a lot of questions, people saying under new presidential administration, do we have to worry about this as much? It doesn't matter. This has nothing to do with that level. This has everything to do with securing health records and making them accessible. It's a bipartisan law, has always been bipartisan, cries from both sides of the aisle for greater enforcement because healthcare historically has been a leaking vessel of sensitive information. And there's been nothing really to protect it but HIPAA, which wasn't really being enforced. There was no audits going on. There was just nothing really to really get us moving in that direction other than just, you know, doing the right thing. Not anymore. That's certainly changed, and it is definitely a law that we cannot sweep under the rug anymore. If you look at the acronym, Health Insurance Portability and Accountability Act, two key words missing in that acronym, Health Insurance Portability and Accountability Act, the two key words are privacy and security. They're not even in the acronym, but that's our biggest challenge.